Hey, everybody. Good morning. I wasn't really happy with the briefing of the case, particularly late in the lecture, so I wanted to record an extra support, put it up on YouTube, and then you could view it. Would help you while you're reading Simpson on Shelley. And I'm not even going to say more than I normally would. Briefing a case, I'm going to provide some guidance on how counsel for Wolf and counsel for Henry Shelley can defend their clients to get you. This is a difficult case from the 16th century, and I want us to get off to a good start. So to brief the case, just to start with the issue, because I'm not going to get into the fact profile. I'm going to assume that you can pick that up by reading Simpson, and that you also have slides. But the legal question is, was Henry Shelley's ejection of Nicholas Wolfe, who was the tenant of his uncle, Richard Shelley, was Henry Shelley II's ejection from the properties, Warminghurst and Barnhamwick, was that lawful? Could he do that? And the only way he could do that is if he was the proper lord and his uncle was not. So that's the general question. And the judgment from the court is going to answer this question. Yes, it was lawful, but how did we get there? And you need to understand how we get there in order to make sense of the case, to understand the reasons behind it, or to represent your clients in a moot. So the first sub-question of the general question is, was Edward Shelley's common recovery complete? Remember, common recovery allows the grandfather of Henry Shelley II, allows his grandfather to have cut the tail to get out of the rigid rules of inheritance and to will the land to whomever he wants. If the common recovery is not complete, then the land would go by the rules of descent to Henry Shelley, not to his uncle, Richard, and the case would be over. So that's the first point. If you're counsel for Henry Shelley, the first thing you can do is say, Your Honors, this common recovery wasn't complete. He died before it could be, or he was dead for 10 days before the papers could be delivered. So if it wasn't complete, this favors Henry Shelley to the detriment of Wolfe. If you're counsel for Wolfe, you have to say, Your Honor, the common recovery was complete. We have the legal papers. Here they are. Now, the court is going to rule in favor, historically, of Richard on this point of Nicholas Wolfe. He's going to say, the court is going to say this common recovery was complete. So their answer is going to be yes, but then that goes to a second question, and that did the recovery take place immediately? In other words, on his deathbed, was Edward able to give a will that would direct the property outside the rigid rules of inheritance to his second son, rather than toward his grandchildren, the children of his first son? So if it took place immediately, then on his then he could say, I want this to go to the second son and not to marry my granddaughter. So that ends up being the second one. So if you're arguing for Nicholas Wolfe, that is for his lord, the Henry Shelley's uncle, Richard, you have to argue that it took place immediately. If you're arguing for Henry Shelley, trying to eject Nicholas Wolfe. Here you'll need to argue no, it didn't take place immediately. It was delayed. The court's going to rule that it did take place immediately. And therefore, in these first two questions, the court is going to say the will that he gave on the deathbed is valid. But you need to understand when you're counsel which direction you need to take. Those first two answers to the issue, question one here, question two, set up the major issue of the decision. And that is, upon Edward's death and his statement of will, did the terms of that will grant his second son, Richard, the property by purchase, that is, by a gift, by an act of will, by the grandfather, Edward, or was it by descent? Another way to think this is, remember, the grandson, Henry II, is not yet born. So when he crafts that statement of will, that is, when Edward, the grandfather, does, and he says, this land will go to the male heirs of my body, is he naming Nicholas as a person and saying, I want it to go to Nicholas? Or is he only providing a limitation that it needs to go to my male heirs, whoever they are? In other words, is he naming who this goes to, or is he naming a line over time that it goes to? What does a grant to heirs mean? Since the word male is used, there's also an exclusion of females in this case. But that only holds not by rules of inheritance. The rules of inheritance don't exclude females, but the will itself does. And the answer to the first two means that Mary's going to be excluded. So the answer to that question is Shelley's rule. If you use the word heirs of my body, the phrase heirs of my body or heirs, in a statement of will, what you are saying is that you are naming the line of descent. Those are words of limitation. They are not words of purchase. It's such a narrow little finding. But what it does in terms of judgment is it means that Richard took the property by descent, by limitation, as the only living male heir, and he would then be displaced by the male heir who had the stronger claim lineally, and that is by his nephew, his elder brother's son, Henry II. As soon as Henry was born, his claim would be displaced. So if you are arguing for Henry Shelley and the second, and you can go through and you're going to argue no, common recovery wasn't complete, we're doing descent. Or if you're going to say, you can say no, the recovery didn't take place immediately, he didn't have fee simple control, so the will wasn't valid. And then finally, you can say, even if the first two are yes, by naming heirs, those are limitations, and our client displaces Richard when he's born. If you're arguing for Nicholas Wolfe or for the uncle, Richard, then what you need to argue is yes for the first two, and then you need to say these are words of purchase. He's naming Richard in the will, him specifically. He's not just naming a general line of male descent. I hope that clarifies sort of how you as counsel should address the justices as you move forward. How, how the reasoning went through those questions. In terms of general historical significance, which goes a little beyond the moot, but is in preparation for the test, of just a few words. If it would seem on the surface that the court is supporting more rigid definitions for wills, that they're supporting the entailment of land, and that they're supporting uh, ownership by descent and not by gift or sale or purchase. And that might be what they were thinking. But in fact, what they were doing is they were giving a roadmap to lawyers. And they were saying, okay, if you've got a property owner that comes to you, don't say, if you want to be able to give the land away as a gift, in other words, any kind of sale or conveyance by will, don't say you're giving it to the heirs of your body, male, female, whatever. Don't use that phrase, so that you can maximize the control over who the land goes to. And so, in fact, what Shelley's rule does is it provides guidance, which makes land over time more alienable than it had been in the Middle Ages. So it feeds in to owners, to those who possess land, excuse me, to being able to act more like owners of land, which moves us in the direction of capitalism. So I hope that additional little mini lecture of 10 minutes or so helps you out. And if any of you can remain confused, or if you want to come visit me, we can have a phone conversation. I want to provide support. Take care.